Welcome to Rebel Chaser. My name is Gail, and I have a clip for you from Judge John Stevens at the Jefferson County Criminal District Court in Texas. He has a young man in his courtroom who was there for a bond redetermination hearing.
Video that you've seen multiple times now from the gas station.
All right, 23 CR 1656 is called Carl Chopin. Mr. Himmler, this was filed in the 252nd District Court, but I think we put it in the right court here.
I filed it under the cause number, so it should have a separate writ number.
Well,
this is a writ.
I see a petition for writ.
Correct.
Right.
So it'll have a writ number and probably is assigned in this court.
CR 1656, which is this.
That's the cause number, not the writ. In other words, when it's processed, it'll have a writ number attached to it, not the cause number.
It says, I see something January 24th. You sent to Judge West. Please advise I'm representing. I will be filing a writ for bond reduction. Is that for this case?
That's correct.
What's the bond in this case?
$250,000.
Okay, go ahead.
Your Honor, the court can review the indictment. First of all, you'll see that there's no enhancement allegations in the indictment. This is a serious bodily injury assault case without, as I said, enhancement allegations. So it's basically a non-aggravated second-degree felony case. The bond is set at $250,000. And just to be clear, I'm assuming that the court has granted the application for the writ, and we're here to determine whether relief requested in the writ should be granted or not. So we're conducting a writ hearing.
The court always opens the door for consideration of bond issues.
Right, but in the context of the case before the court, we're here on a writ of habeas corpus, an application for a writ of habeas corpus. I'm assuming since we're having the hearing that the court has granted the application for the writ, and now we're proceeding to determine whether the relief requested.
Okay. Whenever you become that wordy, why wasn't a motion for bond reduction filed?
Because a writ of habeas corpus is the proper way to address bond issues. And, and actually, there's an interlocutory appeal from the writ as opposed to a motion, which it would be.
Yeah. Now we get into the part of the matter, but at the end of the day, it's the court looks at it seriously and under the rules of law. It's the same. So go ahead.
Well, Your Honor, the purpose and the reason, if you'll bear with me for a second, the reason for that is if the court is not clear on whether the writ has been granted or not in this context, the appellate remedy is mandamus, not an interlocutory appeal. So I just want to make sure that what we're talking about is whether the relief and the writ is going to be granted or not. Thus, an appeal would be proper, not that the court refused to grant the actual application for writ of habeas corpus.
Number one.
Okay.
Once again, sometimes when we want to try to read things into the law, there is it loses the practical method of why it's all about, and why it's written and what it's there for. Right now, upon what you said, I produced the man right here, which is what you've asked for.
Correct.
Okay, all of that word, it speaks for itself. He's standing right there.
So the application.
So issue a writ and require to produce the body. I have done that. Okay, what's next?
So we're proceeding on the relief requested.
God bless you. How else can he be here unless he walked from the jail or was escapee and he's come on? Let's be practical.
I've had this issue come up.
He's right here in front of the court by your application for writ. I produced him.
Your Honor, at this time, if the court's prepared to hear evidence on the relief requested in the writ, I could call it Takesha Gilbo.
Go ahead.
Ms. Gilbo. And she has not been sworn. Come up over here. Stand back here. Right. Stand away from.
Raise your right hand. You solemnly swear or affirm any statements you make during this hearing will be the truth, the whole truth, and nothing but the truth. So help you God. Lower your hand.
No,
Go ahead.
Well, I'm going to do that. Would you state your full name?
Akira Gilbo,
And would you spell state your full name? What is your full name?
Akira Jamal Gilbo,
Deny it. Spell your name.
CYKERIA JANIAHGILBEAU.
Ms. Gilbo, how old are you? 20 years old. Where do you live?
In Baytown,
Do you know the defendant Carl Chopin?
yes, sir.
How do you know Mr. Chopin?
Yes,
Boyfriend, is that right? In connection with this hearing today, did I ask you to collect some information?
sir.
Did you, in connection with that, contact 3 separate bonding companies licensed in Jefferson County?
Yes, sir.
And did you inquire as to each of those bonding companies, what they would require as far as payment for a $250,000 bond in this particular case?
Yes, sir.
Which 3 bonding companies did you contact?
Bell America, Alvy, and Ella.
And as far as each of those companies, did you also not only ask what they would require for a $250,000 bond, but for a $100,000 bond and for a $50,000?
Yes, sir.
As far as Bail America, what did they tell you as far as the bonding requirements, financing, payments, co-signers, that type of information for those 3 bonding amounts in this particular case? What were they requiring?
Bell America offered for the 250, like the regular bond, they offered 10% of the bond, and they wanted 4 co-signers with 8 monitors. And for the 100,000,
How much were they required down on the 250,000? Of the 25,000, how much did they want actually paid up front?
10,000.
$10,000. Okay, what about the 100,000?
Well, wait. $100,000 bond are we talking?
This is
All I have is 23 CR 1656. That's all I have before me.
This is to show his ability to make a bond in a reduced amount. or
Okay,
inability-
I only have this aggravated assault in front of this court, right?
Correct, and the bond in that case is 250,000. As part of the proof necessary, I have to demonstrate that he can't make bonds even in a reduced amount to establish what would be a reasonable bond. That's why I'm inquiring as to the financing and requirements on lesser bonds of 100,000 and also 50,000 in addition to the bond as it's presently set at 250,000. Which I think is a requirement to prove.
Go ahead.
Okay, I'm sorry, Your Honor.
Go on. We'll be here all day. Let's go. I'm not stopping you. I'll forward.
All right, so what did they tell you on the $100,000 bond, Bail America, the financing and the requirements?
For 100,000, they just offered 5,000. Sure, go back.
100,000?
Yes,
What was the total amount of the bond that they wanted on?
it was 10,000, or they was 10,000, the really wants 500.
Up front,
Yes, sir.
you still have to pay the other 5,000.
Yes,
Payment, monthly payments?
sir. Yes, sir.
What about a $50,000?
The 50,000, they offered 5,000, they reduced to 5,000, and they want 30,000 as bonuses.
And then finance the rest of that, is that correct?
Each month.
And with all of those bond amounts, they would also require a GPS monitoring device to be installed
Yes, sir.
on their own, even without a court order, is that right?
Yes, sir.
And they wanted four co-signers with each bond, is that right?
Yes, sir.
Or was that just to get $250,000
It's all free.
for all 3? What about Al Reed? What did that bonding company do? Mr. Al Reed, Bill, what did they tell you as far as the 250,000?
For the 250,000, it was the same for the building, they just wanted to do the 10, and we put 1 thing.
Up front? What about a GPS device? Do they require that
You know, so they just. need 15,000.
up front?
Yes, sir.
And then finance the balance of that, the 15,000?
Yes, sir.
So they just want 10,000 up front?
Yeah,
How many co-signers did they?
for
What about for a $100,000? What did Al Reed require?
100, they just reduced it to 10, they just wanted 5 months. Up front, 5,000 up front.
And then 5,000 finance?
Yes, sir.
Let me be clear on the $250,000 bond with Al Reed. They wanted 10,000 up front, and you had to finance 15,000.
Yes, sir.
That's what I thought. So what about the $50,000 bond with Al Reed? I mean, I'm sorry, yeah, 50,000. What did they require?
They just wanted 1,500 or 50,000.
Down,
Yes, sir.
then how much was the total amount for the bond?
5.
And they would allow you to pay the balance of the, what would that be, 3,500?
Yes, sir.
How many co-signers did they?
2.
What about, what was the third one, professional or allied? Allied.
Allied.
Allied. So what did Allied Bill Bonds tell you regarding the $250,000?
They just wanted 10%, so $10,000.
Well, did they want 25,000 total and 10,000 down?
Yes, sir.
So they would finance 15,000.
Yes, sir.
How many co-signers did they have?
2.
And did they require a GPS device?
Yes, sir.
What about for a $100,000 bond?
It's the same thing. They wanted 10%.
So $10,000, how much would they take down?
5,000.
And finance by? And what about a 50,000?
3,000.
3,000 down,
Yes, sir.
and then finance percentage.
Yes, sir.
Now, are you familiar with Mr. Chopin's finances?
Yes, sir.
How long have you known him?
3 years.
3 years? Do you know if he has any savings accounts or money invested in stocks and bonds, mutual funds, ETFs, any type of investment, anything like that?
Yes, sir.
What is it? What are his finances to your knowledge?
He has a bank account.
You know what the balance is in the account? Other than a bank account, which we know what bank it is. Other than that, do you know if he has any real estate, any investments, any cars, anything about passwords?
Right. So you stated you've known Mr. Chopin for 3 years.
Yes, sir.
Were you aware that he was charged with and ultimately convicted of murder of a building that occurred on January 6, 2021,
Yes, sir.
and that he was placed on probation for that offense?
Yes, sir.
So you were with him during that time frame.
Yes, sir.
And so you must also be aware that he was, a motion to revoke probation was filed on him in April of 2022, and that he was sentenced on that to 12 months in the state jail. And you stayed with him through that entire relationship.
When was he sentenced?
First off, ma'am, do you know that answer? What the judge just asked?
Specifically,
I told you it was June 22nd, 2022. That sound right? And again, you're here saying you've known this man for the last 3-4 years. You remember that? Okay.
No, I believe I'm going to object to the state characterizing it as 3 or 4. I believe her testimony was 3. And accuracy to the record. She testified she was convicted.
The record will speak for itself. Go ahead. Ask your next question.
Do you remember that when his sentence expired on that burglary of a building, when he got out of state jail? I'd represent to you that it was March 5th, 2023. Would you agree with that? Is that a yes?
Sure.
All right. So basically, so right now we're in February of 24. So about 11 months ago, he got released from state jail
Yes,
from
sir.
that 1-year sentence he received. Right?
Yes, sir.
Now, were you with him on October 1st of 2023?
Yes, sir.
You're aware that of the situation that he's accused of beating an individual by the name of DeLorean Jefferson at that gas station, along with some 8 other defendants. Now, I want to make sure, were you with him on this occasion, ma'am? I mean, actually at the gas station? Did any of those bonding companies that Mr. Kimler just talked with you about, did they mention either one of those facts in assessing the amount that they wanted for these bonds? And specifically, we'll deal with it, we'll break it down. Did they talk about how he had the prior state jail felony conviction? Did they talk about, the second thing, did they talk about the notoriety of this particular offense? So they didn't mention either one of those things to you? That's witness.
Nothing further.
All right, next. Next.
Lisa Chopin. She has been sworn in.
Okay, you ready? Raise your right hand. Do you solemnly swear or affirm that the testimony you are about to give shall be the truth, the whole truth, and nothing but the truth, so help you God?
Sure.
Would you-
Go ahead.
would you state your full name and spell your full name?
Felicia Nicole Chopin, FBLE, Nicole NICOLE, Chopin, CHOPANE.
Mr. Chopin, I'm gonna go ahead and ask you this in anticipation of your hand asking you this. You ever been convicted of a felony in a certain jurisdiction? Ever been convicted of a misdemeanor crime of moral turpitude such as theft or false report to a peace officer or anything like that?
Most
Where do you live or reside?
Hampshire, Texas. Hampshire, Texas.
And which county is that in?
Jefferson.
And how are you related to Carl Chopin?
That's my son,
Biological son?
my stepson.
Stepson. Did you rear him from a child?
Yes, sir.
From what age did
8
you?
years old.
From 8 years forward, is that right?
Yes,
Where was he reared? What county?
Jefferson County.
What high school did he graduate from, if any?
He was in Ozan, but graduated early. Evolution Academy.
And that is in Jefferson County? So he has been a resident of Jefferson County up until the time he graduated from high school, is that correct?
Correct.
At some point, did he move to Baytown?
Yes, sir.
When did he move to Baytown?
So it might not even been quite 2 years yet, maybe a year or 2 years.
Between a year and 2 years
Yes,
ago.
sir.
And Baytown is in Harris County, Texas, is that correct?
Correct.
Since he moved to Baytown, have you maintained contact with him? Speak with him, is that right?
Yes.
Do you know if he's related to anyone in Baytown, or what was the reason that he moved to Baytown, Harris County?
His girlfriend, and he had got a job there.
Where was he working in Baytown?
It's a grocery store, a couple of miles on Main Street. I don't remember the name of it.
And to your knowledge, he's gainfully employed or was gainfully employed in Baytown, is that correct?
Correct.
Before going to jail, is that right? What other family members does he have in Jefferson County besides yourself?
My husband, his grandmother.
So would you agree with me that he has substantial ties to Jefferson County?
Probation.
Would you be willing to act, you heard Ms. Gilbo reference a co-signer on a bond, would you be willing to co-sign a bond and be responsible for his appearance in court?
Yes, sir, that's my son.
Last witness. Ma'am, you've heard the questions I asked the other witness, did you not? You were paying attention, not working.
Yes, sir.
So when I represent to the court that this man was on probation for an offense from January of 2021, you were familiar with that, right?
Correct.
That he was in fact sentenced to a year state jail.
Yes.
And that was approximately in June of 2022.
Correct.
And he was in custody all the way up until March of 2023.
Yes.
So this offense that we're dealing with is roughly 7 months after he gets released from custody. When I know you stated something to the judge about his employment. When did he get that job? Where in that time frame did he get that job?
I don't actually know dates, but he worked there for several months. Hadn't been a year yet, but it was several months.
So was he working in Baytown before this offense occurs here in Jefferson County?
Yes, sir.
Do you know why he was back in Jefferson County if he was working in Baytown on that particular date?
He had an off night and came to visit me and was at the store to get ice cream. And that's why he was at that store.
Were you there?
No, sir, I wasn't.
Have you seen the video?
Yes, sir, I did.
All right. Nothing, brother.
just briefly, are you familiar with his finances?
Yes, sir, well, before, the job, he was working the job, but here recently, I have an account for him.
How much money is in your account? Is that your account for him or is that?
I opened it up a while back.
How much money is in that account?
$500.
Other than that $500, does he have any financial resources?
Well, he's not employed at this time, but no, sir.
Does he own his own vehicle, on his own car? Does he own any other real property like a boat or a trailer or a motorhome? Anything of value that he need?
No, sir.
Does he own any real estate, any houses, any property, anything like that?
No, sir.
Does he own any investment income, stocks, bonds, mutual? So the only money that you're aware that he actually has the scope to pay for a bond is $500. Is that correct?
That's just what's in favor. There had to be,
How much-
he's responsible for.
Do you know how much money he has available to pay for a bond other than that $500?
With the help of myself and his dad, we will, but yes, he only has the 500.
Presently, the bond is amount of $250,000. You've heard Ms. Gil's testimony about that. The resources available to Mr. Chopin, are you available to, would you be able to post that bond?
Yes, sir, he will be.
$250,000.
Well, we were asking for some help, for it to be reduced.
So you can't post the bond in the present
Not
amount?
$250,000.
That's what I'm asking you. You can't afford to post a bond in that amount, is that
No,
right?
sir.
And he can.
No, sir.
What about 50,000? Could you afford that bond based upon what Ms. Gilbo found out from the bonds and what would be required down payments and finance?
Yes, sir.
Would a bond in that amount, in your opinion, reasonably assure his appearance for trial to contest this case, like this case, and go with it?
Yes, sir.
What about a bond in the amount of $100,000 for trying to raise the money necessary to post that bond? Have you been successful at that?
Yes, sir, yes.
You've tried,
We will be able to try to.
but as it stands now, could you post a bond in that amount, $100,000? That's what it's Writ does.
No further questions, sir.
You can sit down. Your Honor, I think that's all I have. I can, except for argument.
All right, anything else from the state?
No, yeah.
All right,
I mean, I do have argument.
well, before you argue, Court has something else to add from the file here. Thank you. The defendant was brought up. The defendant had, even though it's not part of the indictment, was brought up that the defendant had been previously convicted of burglary of a building. And the court's files, the records in this case, it's cause number 234712. And in that case, which was presided over by Judge West next door in the 252nd District Court, the defendant was placed on deferred or unadjudicated probation for burglary of a building on January of 2021. He reported 1 month and then absconded. And he was pleaded true to failing to report to the probation office since on or about February 1st of 2021. Again, he was placed on probation January 6th. Within a month, he was absconded after his first report. He also pleaded true to providing a urine sample on or about February 4th. On that day, he last reported that showed the presence of tetrahydrocannabinol. Both the court found there were violations of his conditions of probation. And in the bail factors that we look at under Article 17.15, the nature of the offense and the circumstances under which are committed are to be considered, as well as whether the offense involved a crime of violence. Other bail factors include whether the defendant has previously complied with bond conditions, any aggravating factors in the charge. The thing that bothers this court, other than the circumstances of this case, which are quite disturbing, and that is he absconded from probation within a month and was caught using illegal drugs. And I'm waiting for information from the probation office to see how long he had absconded until he was arrested. I don't know that. I want to know when he was arrested after he absconds on his court-ordered probation. The point being, if he can't follow those rules, he's certainly not going to be treated favorably under the bond factors. He has failed the previous test royally on reporting responsibly, following the rules not to commit other crimes. Illegal use of drugs is a crime, and admitted to those. Also failed to provide verification of any community service hours that were required. If he can't follow those, I want your argument to address the issue here. What is it a bond condition is going to do when threatening to put him in a prison facility for violations didn't stir him to follow rules? Go ahead.
Your Honor, I think that I'd have to look at the motion to revoke, but of course, failing to report.
There it is.
Failing to report.
After 1 month and absconding.
Yeah. I want to say it was just a number of times that he failed to report. It's never reported. It appears that he did ever report to probation. I would just state to the court that that's a state jail felony case. Obviously, it's a felony in serious. You go to state jail for 2 years. What he's facing now is 2 to 20 in the penitentiary with a bond that I'm sure, even if it's not $200,000, will be significant enough that should he fail to appear, he would be putting the co-signers at risk on that bond who are going to have to co-sign for him, which I assume is going to be his stepmother and other family members, that he would put them on to be responsible for the amount of the bond forfeiture if he doesn't appear for court. To have that responsibility.
Why would he care about them when he didn't care about himself and his own freedoms here in this probation that he was just on?
I could just relate to the court that it's been my experience when there are some people who have the responsibility not only for themselves, but know that their family members can be responsible for a substantial amount of these bonding fees. That does tend to be an incentive for them to show up to court. It also incentivizes the co-signers, should there be a bond forfeiture, to work with the bond agent to make sure that he's returned to custody, that there's a way to get him back into custody. That's the reason they require co-signers.
So you're saying, wait. So you're saying that not following conditions of probation from the beginning and knowing that would certainly, as an absconder, likely lead to revocation of probation and confinement for a felony and a conviction of felony, you're saying that doesn't bother your family?
What I'm saying is, Your Honor,
it does. So it's the same argument. He knows he hurts his family when he does something like that.
Perhaps. I would also add, Your Honor, that should the defendant fail to appear in court, there's an additional charge of bond jumping that would be available to the state. It will be a fairly easy case to prove. That's one level above, I believe, what the charged offense is. So thus he would be facing a consecutive first-degree penalty range potential.
He did it. Argue this. He's already absconded before. Why wouldn't he do it this time?
Because the stakes are so much higher here than on a state jail felony case. Your Honor.
Oh, it's just a matter of the degree of stakes?
I think if a person understands that if they fail to appear for court, they could be charged with a first degree felony, that's 5 to 99 to life. They could actually be stacked, the time could actually be stacked on the second degree case, but that would tend to incentivize them
But
not to miss court.
But you're saying it doesn't have anything to do with the fact that it's right versus wrong and it has its loss. Failing to follow the bond conditions.
I agree that.
All right, well,
that-
but he's already shown he doesn't care much about the rules before, the same kinds of rules.
I would just
Why
say
would there be a difference now?
contextually that this is different because the stakes are so much higher. There's a different context here. But also, as the court is aware, this probably is not going to be a probation offer from the state. Anticipating Mr. Ham's offer on this, if Mr. Chopin wants to avail himself of a jury trial or even pleading the case guilty to a jury, he's going to be in pretrial detention for a substantial amount of time, as many other people are. And that's another consideration I'd ask the court just to be aware of is the length of pretrial detention, that if we refuse the state's offer, we want to plead the case to a jury or go to trial on it, that there's going to be substantial length of pretrial detention that the court could address in this case by allowing him to post bond and requiring him to have a GPS. In other counties, if we had a pretrial services department, which we don't, he could actually be ordered to report regularly to a pretrial services officer.
You mean like he failed to do when he was on bond,
Again,
when he was on
if
probation
he-
before?
if he
No,
fails-
no, no. Let's, like he failed to do before? You're not changing those facts. To me, that was a serious situation. And I mean, 1 month and he was gone.
I can't change.
He didn't care about the rules. He knew what was responsible here. He might lose his bond. He had more at stake.
I can't change the past. Your
I
Honor.
know you
It
can't
is- it
change
is what it is, and obviously the court can consider
And
it. I'm just saying that
But the past are facts. You're hypothesizing.
Well-
The facts show he is frivolous in following the rules.
certainly the best indication of future behavior is past behavior, but obviously people learn from their mistakes and can make changes. And I would just simply argue the court, a bond in the amount of $250,000 is excessive. I mean, the court can provide the incentive necessary for him to be in court to deal with this case with a bond and a lower amount.
You
The
make-
court would make some kind of, I mean, there are people in that are on bond for substantially less that are charged with murder.
Okay.
in this case.
Anything else?
No, Your Honor.
The court, his bond is $250,000 now. I'll reduce it to $200,000. In the following conditions, he must have home confinement, he must have a GPS device, he must have a drug patch. There will be other terms and conditions of probation that this court may also address if and when he is able to produce that. But the problem he has is his history and his track record. He was on probation in cause number 234712 for a burglary of a building, reported 1 month, then absconded. I don't have the exact date when he was, does probation know on this case what the date was that he was taken back into custody on that? That's all.
They're sending someone to answer those questions for you, Judge.
You could probably pull that up.
No, I can't. No, we can't. We have the motion, and when it was filed on April 12th of 2022.
When were you taken into custody? When?
May.
May 14th,
Of what year?
2022.
Yeah, he has absconded a year and a half. He absconded almost a year and a half. And you always fight valiantly. Here, this isn't a good set of facts to show that he can follow rules. No, you didn't. You royally failed. And the one thing you have to do is report. And that's key to a bond condition. And you made F minus. Very few people on my watch abscond from after a month of probation. And then we're involved here with, and not only that, but also failing to follow the rules by failing the drug test. He has drugs in his system a month into his probation. So those are the two main issues for probationers: not committing crimes and reporting. And he blew those away royally. Then he's charged here with this aggravated assault with a deadly weapon. This court has seen and has dealt with the hearings on this matter. And the circumstances of that are terrible. And that's under Article 17.15, rules for setting amounts of bond. The nature of the offense and the circumstance which it's committed are to be considered, as well as whether the offense involves violence. Here, whether bond factors are included, such as whether the bail factors are to be considered, whether he has previously complied with bond conditions. And this court would say that probation terms are first or twins to bond conditions set, since they work in the same manner. That is, there are ramifications to the defendant's liberty if he fails on bond conditions. But here, when you're on probation, after you have been admitted guilt of a crime, and then you frivolously mishandle your responsibilities of reporting and obeying the law, that proves that the defendant is a risk to the community. And I've seen, again, back to the circumstances in this offense, this is an offense that occurs at 3 o'clock in the morning, where a group of people have essentially taken over the convenience store, where no one, the group of people were so large, no one who wanted fuel, who was running out of gas at 3 in the morning, could get fuel, because all the pumps were taken over by vehicles that were there for a party atmosphere. It had nothing to do with buying merchandise. If someone needed milk for a child, the only stores that are open really are convenience stores. And it was packed. Somebody could not safely navigate through this crowd to get into a convenience store, and they wouldn't want to. They'd be intimidated. A mob had taken over a business, and this city, as far as that area was concerned, was essentially shut down for anybody to be safe in. And then the beating of this man, who was put in a coma type condition, occurs, and this defendant is charged with his involvement, according to grand jury, aggravated assault with the use of a deadly weapon, namely a firearm. All of those reasons point to the fact that this defendant does not fit under the rules leniency in consideration of bond. And the rules and the law that I've described and the circumstances that this court has enunciated are in the record, and those are the rules set forth for the bond in this case.
Yeah,
That
can I clarify one? You said home detention. Do you mean home Baytown or home Jefferson County? What is home?
the last place he was indicted by, his home was supposed to be 3400 apartment 404 Beaumont.
Oh, so that's home.
That's what the indictment says.
If that changes, then they automatic bond if the court would grant me latitude to determine residence.
You bring it up to me, and then we'll take that step when we need to. Anything else? That's all.
Thank you all so very much for watching, and I'll see you next time.